morning, Mr. Brown. Ms. Graham.
Thank you. Good morning again, Mr. Brown.
Good morning, Ms. Graham.
Just to recap where we got to yesterday, I'd explained that we would deal with 3 periods of time. We were still on the first period of time, which was from the 3rd of May 2015 up to August 2015. But we were heading towards the end of that period. And I think by the stage we got to yesterday afternoon, we were aware that the Lord Advocate had wanted further investigation into the cause and mechanism of death. That PERC were engaged in a process whereby they were identifying medical experts and experts to suggest to Crown and then to instruct. And they were also obtaining CVs, and they were going to prepare letters of instruction in draft and then send them to Crown for review.
Yes, they were going to prepare that once the Crown had assessed the information and ultimately, as I said yesterday, approved the instruction of the experts.
And that was a process that was entered into between the Crown and PERC, but it wasn't something that had been a long established protocol or anything of that sort.
I think that's a very good way of putting it, that to some extent this was exploring or progressing something that was relatively untested and novel, yes.
Right. And we've heard evidence from the lead investigator at that time. That was a Mr. McSporran. And he took us through his policy log where insignificant decisions and such like were noted. And he referred to one, in fact we could look at it briefly, PERC 04153. And if we look at decision 59, and you'll see in the final column on the right hand side the dates are given when Mr. McSporran noted these entries. And you can see there for the 7th of July, it says in the middle column, to obtain expert medical opinion on cause of death and or potential contributory causes. And it says provide expert witness packages. And there's various items listed that were to be prepared within that. So yes. By early July, 7th of July, these discussions about instructions had begun.
Yes, and that does accord with my recollection in relation to the timeline, and I'm pretty confident that meetings had already taken place involving the Lord Advocate, where the Lord Advocate had indicated that he considered that this required exploration, and that it was around about this time that he was indicating that he wanted experts to some extent from the international community, if possible, to look at this.
And Mr. McSporran noted that this was to obtain expert medical opinion on cause of death and or potential contributory causes. That seems to be his understanding. That's what he's noted.
Yes, I see that, yes.
Right. And then if we look at 62, decision 62, see it says narrative instruction of experts. This is another entry by Mr. McSporran, but towards the end of July, the 29th, following presentation of CVs to Crown Office, they have instructed PERC to engage the services of Dr. John Payne James and Dr. Stephen Karch to provide expert opinion on cause of death. So by the 29th of July, it would appear that CVs had been sent to Crown Office, they'd been reviewed, and PERC were now at the stage of instructing the services of 2 experts, Dr. John Payne James and Dr. Stephen Karch.
Yes.
And it would appear that Mr. McSporran's written this down as providing expert opinion on cause of death. Now, I think in your own statement, you've explained that it was you who was reviewing the CVs of the experts.
I did have involvement in that, yes, but I'm confident that others did as well.
Right.
Yes.
Was that someone from your team that you spoke about yesterday, or colleagues such as Mr. McGowan?
I'm very confident it involved Mr. McGowan because I know that Stephen McGowan was in agreement that that those experts, in particular Stephen Karch, that it was appropriate to instruct. I'm consider that it likely that others were cited as well, perhaps including the Lord Advocate, because of the interest and because of this particular interest that the Lord Advocate took, but certainly Stephen McGowan.
Thank you. Do you remember now the expertise that Dr. John Payne James had? What field of expertise he worked in?
Yes, I know that he was, I think the description, a forensic physician. I recollect that he had experience and direct experience and a particular interest in restraint within a variety of settings, including a law enforcement or a police setting. As I recollect, he had contributed to a number of publications in respect of that, and that he had been involved in building up a high degree of knowledge in relation to those, and he was, I think, in a position whereby he contributed in an advisory capacity to restraint and I think safe methods of restraint.
Thank you. And Dr. Karch, what was your understanding of his expertise?
Dr. Karch was put forward in relation to, as I recollect, his knowledge and his experience of the effects of drugs on the person who had taken the drugs, and the possible physical effects upon a person who had taken those drugs. So as I understand it or recollect it, he was being approached to comment on the role of the drugs that had been taken or had been detected in this case, and what effect those might have in all the circumstances.
We've heard from Kate Frame, her understanding, it was Perk that put his CV to the Crown, that he was a cardiac pathologist and a toxicologist. Would that accord with your recollection? Or does that go beyond your memory of?
It probably does go beyond my memory to some extent, but I do remember that it was a long CV.
Right. Were you aware at that stage that Dr. Karch was an advocate of excited delirium?
No.
Were you aware of any of the controversy at that time around excited delirium?
No. But I do remember Mr. Anwar talking about excited delirium. It may well have been around about that time, and highlighting that excited delirium was something that any investigation should be, I'm not quoting him directly, should be wary of and careful about, if I can put it like that.
And you would have been aware from the final post-mortem report that Dr. Shearer and Dr. Buhadir had said they'd considered the possibility of excited delirium, but they didn't consider that to be a pathological diagnosis.
Yes.
It may have been a psychiatric diagnosis.
Yes, and more particularly, my recollection is that it couldn't be a cause of death in itself, but might be a factor to be considered.
Thank you. I think we've heard evidence, and I summarise here, that in the UK at least, excited delirium would not be a cause of death, and certainly not one that a pathologist would put forward.
Yes.
Before I move on to the experts, as I understand it, and as we noted in the policy log, PERC were also instructed to prepare an expert witness package. And I think you have said in your statement that you were satisfied it was appropriate for PERC to compile an expert witness package. I'm interested in this element of the instruction of the experts. Mr. McSporran said that he and Billy Little personally prepared that package, but we've also heard that there were some issues. In particular, there was an issue with the statement from Ashley Wise, where a significant section of her statement had been omitted, and it was, having been omitted, her statement, an incomplete statement, was sent to experts to consider, and then that matter had to be, attempts had to be made to rectify that.
Yes, I do recollect that was something I think that the Crown had identified and explored and then pointed out and taken steps to address.
In hindsight, do you have any views on whether it would have been better for the Crown to prepare that package?
My recollection is that that the expert pack was shared with the Crown team, and I, at the time, as I think I indicated yesterday, I don't recollect, and in my preparation for this inquiry, I haven't come across any indication by PERC that they were having difficulties or struggling or considered that they weren't in a position to progress this. As I indicated, I'm confident that there were meetings, perhaps not every one of which I attended, between the Commissioner and the Lord Advocate and perhaps some other senior officials. But with hindsight, clearly, the method of instruction of experts and the material that is provided does require careful consideration, and to that extent, if the inquiry considered that it would have been appropriate to have a different approach, then clearly with hindsight that's something that would have to be recognised. But I say it as at the time, and bearing in mind that there was consultation with the Crown, and in the light of the fact that I don't recollect any expression of difficulty, and that the Commissioner herself seemed confident that they could progress that, that was the way that matters proceeded, and that I don't want to speak for everybody in the team, obviously, including law officers, but there was an awareness that this was the approach that was being adopted, and everyone seemed content with that approach at that stage.
Right, thank you. But in hindsight, do you think that perhaps the Crown would have been better placed to take the care required to prepare an expert witness package?
Just give me a moment to think about that. I think the more input you have in relation to this kind of instruction, probably the better, provided it's well informed. But as I say, there was a sharing of all of the information. There was a sharing of the CVs. There was then an expert witness pack to be prepared that was referred to by the Commissioner. Quite how much input the Commissioner had, I obviously don't know, but it was put through the Commissioner, and in the light of all of that experience, that was relevant experience in the selection of experts, I consider. But as I say, I think that there could be some benefit in having a wide input in relation to all of that.
Thank you. You mentioned a discussion with Mr. Anwar regarding Dr. Karch and an expression to be wary about his instruction. When did you become aware about, if I can put it, a slight concern or a wariness about Dr. Karch's instruction?
I think that the first time was after Dr. Karch had been instructed, and the inquiry may be aware of this. There was an indication from PERC that during a conversation with Nat Carey, that Nat Carey had expressed a view that Dr. Karch was, I think the phrase used was world renowned, and that was conveyed, and I was aware of that, and I conveyed that to the team and to a law officer, and that was conveyed to Mr. Anwar, who refuted that assessment and indicated an entirely different perspective in relation to Dr. Karch. So it was following his instruction, and that certainly sticks in my mind because it was direct. I was there when Mr. Anwar said that at a meeting at Crown Office. Whether he had expressed some opinion in writing before that, I'm not entirely sure, and I don't recollect that here. But
with Mr. Anwar being so direct and expressing those views in relation to Dr. Karch, did you take any steps at that point in relation to the instruction to Dr. Karch? You've said it had already gone out.
Yes, and it may well have been that he had reported at that stage as well. What was done in any event was that the report of Dr. Karch and the report of Dr. Payne James was disclosed to the original pathologists for their assessment and review, and that was done at that stage, around about that stage, and that was not driven by the comments that Mr. Anwar had made. That was part of the overall process that the Crown was embarking on at that time. There was also, I think that was pretty much contemporaneous with certain comments that Dr. Karch had been reported as making in the press, and that attracted some comment and a view taken that the opinion of Dr. Karch should be treated with extreme caution and care. And in fact, the Lord Advocate was very clear, I think I said in my statement, that the opinion of Dr. Karch was not really to be given much weight.
I think if we focus on period 1, which ends with the first report, I think we'll come on to Dr. Karch in more detail in period 2. But in relation to those comments, they were after Dr. Karch had been instructed.
Yes.
Thank you. Can I move on to another aspect of Article 2 in relation to this first period that we're looking at?
Yes.
Yesterday, I referred to that first report from PERC as an interim report, and I referred to that, and it was on the 7th of August 2015. It was sent to Crown, and you very rightly picked me up on that and said it wasn't designed to be an interim report, I think. So was it your understanding that that first report from PERC, at the time you got it, in August 2015, that was to be the PERC report?
That was my understanding.
Yes. It wasn't designed as an interim report?
It wasn't titled an interim report, and I don't have any recollection of it being advised and trailed as an interim report.
And although there were still investigations ongoing at that point, we've talked about the instructions for the experts and such like, and PERC obviously had a hand in the instruction of Karch and Payne James at that time. Did that have any impact on your view that it was supposed to be the only report rather than simply an interim report?
No, it didn't.
And so would the Crown have been happy with those ongoing investigations and actions by PERC to simply rest on one PERC report received in August? Had that been satisfactory, which we'll come on to?
Essentially, yes.
And in terms of timescale, because if we look at Article 2 and delay or things being prompt, this was between May and August was roughly about 3 months.
Yes.
And in terms of timescale, from your experience of PERC reports being received, is a 3-month period quite common? Quite reasonable?
I have to say that I don't recollect any previous experience, so at that time I wouldn't have been in a position to assess that. What I can remember is that there was obviously there was a degree of attention and there was a degree of interest in when the PERC were going to submit the report, and that is when it arrived. So looking back in relation to my overall time in CAPD, I know that there were various PERC reports that came in, and they varied in time according to the complexity of the report. I am aware that PERC have internal targets for reporting, but I couldn't assess at that time as to whether this was either quick or within normal experience. But at that time, that I wasn't in a position to do that.
Did it meet your expectations in terms of arriving within a 3-month period?
I think I personally would say that, and I think that there was an awareness generally in the team that that's round about when it was going to be expected, and nobody raised any concerns about that.
There's one comment that you make in your statement. If we could look perhaps at that. This is another matter where you comment on a delay or a period of time. Answer 120 at page 74, paragraph 3. So it's page 74. It may be 75 of the PDF, but it's certainly answer 120. There we are. I consider that the failure of officers, do you see that at the bottom of the page? There we are. I consider that the failure of officers to provide statements at an early stage of the investigation into Mr. Bio's death was a significant issue that caused difficulties to PERC investigators, and with hindsight could have prevented the investigation from progressing expeditiously, particularly in relation to the question of potential criminality. The refusal to provide statements took place following clarification of their status as witnesses and apparently following advice. Were you concerned about the period that it took to get these statements and the impact on the PERC investigation?
Yes, I was. I recollect, I think, that PERC referred to this in the report, but I was concerned in relation to this aspect, and I think that my concern was very largely based on the impact that would have, not just in the overall time, although it would have clearly delayed the preparation of the report, the fact that the statements which were central to the investigation were provided in whatever it was, the early June.
4th of June.
Early June. But rather, that period of time contributed to, in my view, a number of factors. It contributed to a breakdown in trust and confidence on the part of the family of Mr. Bio, and in general, public confidence was something that was a live issue at that time, and in my own view, the effectiveness of an investigation is affected or potentially affected where there is a gap in time between the incident and the provision of statements, because, amongst other things, what can be affected is that the officers, their recollection, or the contents of their statement rather, the contents of the statement could potentially be coloured by information that came to them subsequently. So that's included in the statement, and therefore the earlier the provision of information, in my view, makes it the investigation more effective, because one is getting information very close to the event and then can start a process of comparing, contrasting and progressing the investigation.
Looking back now at that period during which PERC were waiting to obtain statements from the officers and the consequences of that, you've obviously reflected on events, and I'm wondering if there's anything you can think of that could make that period of time more efficient and faster and avoid the delay that was caused. Is there anything that could be done, do you think?
I very much appreciate that this will be probably a matter for the inquiry, but what is it that can secure the early provision of information to allow an investigation to progress? Obviously bearing in mind the right to a fair trial, but also recognising the particular position that police officers are in the light of the fact that they have the right to use force in certain circumstances, and whether that they having that right also attaches an obligation to account for that at an early stage.
And is that something that you would find would be of assistance to the Crown if there was something in place that would require statements or information or basic information to be provided by officers?
Yeah, well, I'm aware generally that is something that Dame Eilish Angiolini did comment on in her report on police complaints and involvement of the Crown and the PERC, and I know that there is legislation in contemplation and enactment in relation to that. I think I do see in my inquiry statement that would have the advantage, in my view, of putting the situation beyond doubt in relation to that. I do think that it does involve quite delicate issues of balancing out various rights. But I do come back to that point that I made, because I did give input into that review to Dame Eilish, and I did comment that the right to use force does attach, in general terms, an obligation to account for that, and that if there is an absence of accounting for it, then the investigative structure can be compromised.
Thank you. I think in relation to issues of public scrutiny and in particular media engagement, I think you've said in your statement that you had a very limited prior experience of media engagement. At this period of time, we've looked at a number of issues regarding the media. In particular, we looked at an article in May that was reported in the Herald. We could maybe look at that briefly. AAC 00379. And this is an example of one of the articles. It's page 7 of the PDF, if we could go to that. And if we can see, it says, custody death, family tells the truth and let us grieve. Lawyer tells of grave concerns over events surrounding tragedy. If we can move up the page, please. There is a section, it's in the second column. There's a You see at the top of that page a quote from Brian Docherty, Chairman of the Scottish Police Federation. And then there's further down, a subsequent quote from Peter Watson of PBW Law. While it is deeply regrettable that Mr. Bio lost his life, I would ask that the media and public to remember that a petite female police officer was chased and then subject to a violent and unprovoked attack by a very large man who punched, kicked and stamped on her. The officer believed she was about to be murdered, and I can say that but for the intervention of the other officers, that was the likely outcome. We all seek the truth, and part of that truth will lie in part in the post-mortem and toxicology reports, which will follow in due course. Calls for the suspension of the officers serve no purpose and do nothing but add unhelpful rhetoric in a difficult situation for all. So this is just an example of one article that appeared in the 15th of May. You didn't have the final post-mortem report by then. We have heard evidence that there were comments made by Mr. Anwar on behalf of the family. There were comments made by Peter Watson on behalf of his clients and the SPF, comments made by the SPF direct. And we've heard that matters became quite tense at times as a result of this. From the Crown perspective, at this stage in May, an early stage in the inquiry, can you tell us what involvement, if any, you had in relation to managing the media or handling that or trying to calm the situation down?
I didn't have any direct involvement in that, but it was something that law officers, the Lord Advocate, was aware of, and the inquiry will be aware that at a later stage there was a release from the Lord Advocate calling for, I can't remember the precise terms of it, but restraint in respect of any comment that was being made, and that was the approach that was taken by the Crown. I don't think it was for me to try to manage this, and I appreciate that in looking at this article, it is quoting organisations that have, I suppose, a particular purpose and a particular purpose in representing, but this it wouldn't be for me to assess that, and I wasn't directly involved. I was cited, however, on the fact that the Lord Advocate took the I was going to say somewhat unusual step of actually issuing a statement.
As head of CAPD, with oversight for the investigation into Mr. Bio's death, did you have any concerns about matters that were appearing in the media?
Yes, I did, and I think that was generally shared amongst the Crown team, and that concern was that we were at a stage of a very sensitive investigation where we had a bereaved family who had suffered a very acute loss, and everyone in the Crown team were aware of that, even by this stage, because we were meeting with the family round about that time. It's difficult to separate out the timings, but certainly Mr. Anwar had particular concerns about information being put into the public domain and to some extent being potentially commented upon, where at this stage, and the inquiry will be aware of the significance of this, there were no live proceedings. So to that extent, any information that was put out in respect of the incident could be published and could be commented upon, and it was those kind of concerns I think that there were generally.
Did these public comments have an impact on the relationship between the Crown and the family?
I don't know that I was aware of anything like that, but obviously the family may have a view in relation to that. I do think that the family would have been aware that the Crown were not supportive of any kind of comment being made, and there being speculation and use of descriptions at that time. I do think the family would have been aware of that this wasn't coming from the Crown, and that it wasn't something that the Crown were either seeking to encourage, and in fact quite the opposite, were of the view that it was unhelpful, if I can put it like that, to the investigation, and also more than unhelpful, upsetting for the family.
Looking back at this period now, do you think the Crown could have done more at that stage to try and shut down comments in the media by those involved?
I don't know of any further steps that the Crown could have taken, and as I say, there was a statement from the Lord Advocate in relation to this that set out the Crown's perspective on that. I thought pretty clearly, and so to that extent, there was action taken, there was recognition, and there was action taken. I'm not aware of anything more that the Crown can do to stop comment being made.
Thank you. And then in relation to the family, so the fifth procedural obligation under Article 2 is in relation to the victim or the next of kin. And I just want to ask you very briefly, we know that the family had meetings with the then Lord Advocate, Frank Mulholland.
Yes.
During that period, the meetings took place on the 14th of May and the 24th of July. Now, we've heard evidence from members of the family and Mr. Bio's partner, Colette Bell, and we also have inquiry statements. It would appear that during that time, Crown engagement with the family appeared to be positive. Does that accord with your recollection of the family's engagement with Crown at that period of time?
Yes, it does. I have a clear recollection of the impact that the attendance of the family had. I think I do refer to that in my statement. In particular, the fact that Sheikh Ubayo's mother was in attendance, having travelled up. That is very impactful in sitting around. And I think that was shared by everybody who was present at the meeting, including the Lord Advocate. Here was a family that were deeply grieving, and were looking for. I know it sounds like a cliche, but at that stage they were looking for answers, and they were also concerned about the provision of information. I do recollect that was a concern, the provision of information at the time of the incident. That was a clear concern at an early stage.
You've said that the meeting with the family, the impression I get from what you said is that was a benefit to the general engagement with the family.
Yes, I think I'm confident in relation to that. That was my impression, but clearly the inquiry will have impressions from the family as well. It's a difficult thing for a family to be coming to Crown Office to meet with law officers, to meet with so-called Crown Office officials. But that was my impression, and I know that Mr. Anwar did reflect that positivity in relation to that round about that time.
And that was of benefit to the Crown also, that the family did come.
Absolutely,
and speak.
yes.
Is it common for the Lord Advocate to meet with bereaved families?
I was asked about this in my statement, and I can only speak from my perspective. It's not uncommon. That's maybe an unhelpful answer. It depends on the particular circumstances. But if the investigation and the progress of the investigation is at an early stage, I think there's recognition that early engagement it demonstrates that from the top of the organisation that there is attention being paid and that the obligations are being taken seriously. And I think that was one of the main purposes of the Lord Advocate meeting with the family, to listen to them and also to put on record that the Crown would this wouldn't be a one-off meeting, but that there would be further engagement. So it was that kind of perspective that I think assisted.
Now, the other aspect that we've heard, as well as the meeting, the other aspect we've heard evidence about is that there was significant disclosure given to the family.
Yes.
And I think when we looked at Alistair MacLeod's briefing note yesterday, the one that was prepared in 2020, there was a mention of the fact that from the outset, Anwar and company were on an exceptional basis, provided with significant disclosure. And I'm interested to what extent you think that exceptional or significant disclosure assisted in the Crown's engagement with the family.
I think it probably contributed to confidence, and confidence, I suppose, in openness, and allowed the family, in particular Mr. Anwar, to be engaged in that process. And I obviously recollect that information was disclosed to allow them to assess that, and also, I think, to instruct their own expert or experts. But the provision of information at that stage, I think, did assist in building up a degree of confidence with the family.
And as the provision of information assisted in increasing confidence with the family, did that provision of information cause Crown any concern at that stage? Was there any detrimental effect providing information to the family insofar as the Crown were concerned?
Not from my perspective. And it was something that the Lord Advocate was clear about as a matter of course at that stage. Yes.
Thank you. We have also heard some concerns from PERC, and these concerns arose more than once, so it was throughout a longer period. But they had concerns that the family on occasions knew things before PERC did. So PERC would contact the family to share some information, and they'd say, we've already been told by the Crown. And that caused them some disquiet. And we heard evidence that they contacted the Crown to raise this issue. Do you remember being involved in any of those issues being raised by PERC?
I think I was asked that in my statement. As of today, I don't have a clear recollection of that, although obviously I don't dispute if the PERC recollect that was a concern, them raising that. What I would say is that I know the inquiry is particularly interested in Article 2 and the obligation and the extent of that obligation to keep to have the family involved in the investigation. I'm not aware of the provision of any specific information that was brought to my attention, because I think that probably would have stuck in my mind. These meetings were to some extent private meetings, in that they were attended by law officers, and I don't think any formal minutes, certainly no formal minutes, were taken in respect of them. So on occasions the Lord Advocate would in the dialogue with the family or with Mr. Anwar, provide certain information in relation to that. That didn't cause me any disquiet. I wasn't thinking to myself at any point, oh, that's crossed a line here, and this will cause difficulties in the investigation. And as I said in relation to the answer earlier on, there wasn't any consideration on the part of myself, nor I understand in respect of the Lord Advocate or any of the Crown team, that the provision of some of the information at that time was anything other than of assistance and to allow the family to assess that and to take appropriate action according to their own investigations and inquiries.
Thank you. I'd like to move on. We've been talking about Article 2, but I'd also like to consider Article 14, which is also of interest to the inquiry. And we've asked other witnesses about Article 15, about rights that have to be protected and applied without discrimination.
Yes.
And we've also spoke to other witnesses about a case called Nachova, which sets out that the authorities have a duty to investigate the existence of a possible link between racist attitudes and an act of violence, and that is an aspect of their Article 2 obligations. But it may also be seen as implicit in their responsibilities under Article 14, taken in conjunction with Article 2, to secure the enjoyment of the right to life without discrimination.
Yes.
Were you satisfied that the members of your team were aware of their obligations under Article 14 as well as Article 2?
I consider that the team were well aware of the importance of assessing race and discrimination as it related to the inquiry. Yes.
Right. And were they aware that where there is a suspicion that racial attitudes induced a violent act, it is particularly important that the official investigation is pursued with vigour and impartiality?
I think in relation to an effective and a fair and impartial investigation, that the team would have been aware of the acute importance of progressing those types of consideration as they related to the inquiry at hand.
Thank you. And during the investigation, any deaths at the hands of state agents, the authorities have the duty to take all reasonable steps to unmask any racist motive and to establish whether or not ethnic hatred or prejudice may have played a role in the events. Are you satisfied that your team would have been aware of those obligations?
I'm satisfied that they would have been relevant considerations in the inquiry overall.
Thank you. And failing to do so would be to turn a blind eye to the specific nature of the acts.
Yes.
Now, yesterday you did speak, and again today you spoke about the importance of race in relation to this investigation into Mr.
Yes.
Bio's death. Could we, I think in your second inquiry statement, you say from an early stage, the Lord Advocate was clear that considerations of race would have to be a focus of the investigation. I think you mentioned that yesterday.
Yes.
We don't need to go to that paragraph, but let's look at your statement SBPI 00419. And I'm interested in paragraph answer 102. This is on page 58. Now, this is a lengthy section of your statement. You talk about race, and I would like to go through the bulk of this with you to ask you for some further comments. So if we start at the beginning, the issue of race was central to the ongoing investigation. Was that your impression from the early stages?
It was my impression that race was an element from the early stages that required consideration.
We had a black man who died after being restrained by police, an immediate instruction to PERC to investigate involvement and interactions with senior Crown Office officials, and the Lord Advocate taking a personal and close interest in the case, all against a background of the officers involved refusing or declining to provide statements on their actions. There had been meetings with family and their solicitor. There was a clear understanding that race had to be a focus of the inquiry, and whether it influenced the approach of police to whole circumstances. And that's a reference again to, you said the Lord Advocate was clear that considerations of race would have to be a focus of the investigation.
Yes.
And that was in particular, as you mentioned there, whether race had influenced the approach of the police to the whole circumstances.
Yes.
So that's not just simply the events in Hayfield Road, it's broader than that, it would appear from what you're saying.
Yes.
And then you say PERC provided assurance prior to submission of the first report, and we know that was the 7th of August 2015, that if racial motivation was identified in the course of the investigation, this would immediately be referred to the Lord Advocate, and race was clearly within the scope of their considerations during the first part of their investigations. And this is prior to submission of the first report.
It is prior to the submission of the first report. That's what I'm referring to, because there was an exchange, as I recollect it, with Mr. Anwar, where race was highlighted, and there was an assurance from PERC in those terms.
We've heard about some correspondence that Mr. Anwar sent on dated the 31st of July,
Yes.
2015.
Yes.
There was a letter direct that he sent to PERC that detailed racial issues that
Yes.
he was expressing were of concern to the family.
Yes, and I read that letter in preparation for my statement, but of course, as the inquiry were aware from yesterday, there had been a meeting at Crown Office where the Lord Advocate had been present, where I was there, and where the Commissioner and I think other PERC officials were there, where there was mention of a racial background, and reference to Baltimore was, as I said yesterday, referring to I think an incident in Baltimore that had occurred shortly before that, so it would have been present in people's minds that had resulted in, I think, considerable unrest because of the actions of police, which had an apparent racial motivation. So there was discussion with a law officer at that stage, and that was prior to the 31st of July.
That was the minutes we looked at yesterday of the meeting on the 14th of May, attended by Kate Frame and John Mitchell.
Yes.
And as you say, by the Lord Advocate and yourself.
Yes.
Can we move on, please? Following my meeting with the inquest and the interaction with the family, following submission of the first PERC report, I submitted a full analysis in a briefing to the Lord Advocate and referred to the Sean Rigg investigation. It also identified areas of further inquiry that required to be undertaken by PERC before a decision could be taken on whether there was evidence of criminality. This relates to the period after the first report had been obtained. Can we see the top of it? No, can we go back? Following my meeting with inquest and the interaction with the family, following submission of the first PERC report. So this refers to the period after the first PERC report.
I'm sorry, can I just take a minute and
Yes.
read this as to whether I've expressed that poorly? I'm very confident that the meeting with inquest that my meeting with inquest, I'd maybe better be precise about dates. It was around about the time of the submission of the first PERC report. because I seem to recollect some emails that I sent to refer to the meeting with Inquest and reference to Sean Rigg and talking about that either the PERC report had just been received or was about to be received, and that this could inform some of the analysis that I carried out. So I'm not entirely confident that the meeting with Inquest was after the submission of the first PERC report. I am very confident that it was before the further instructions that were issued to PERC, and certainly was before, as I recollect it, the analysis of the first PERC report that I was involved in.
Well, we've heard evidence that Mr Anwar's letter to PERC raising race as an issue was the 31st of July. We've then got the first PERC report on the 7th of August.
Yes.
And then we will later come on to your full letter of instruction of the 2nd of September, which post-dated the first report and gave more detailed instructions to PERC.
Yes. I do recollect very clearly that that Mr Anwar's letter was indeed the 31st of July, so I know the letter that you're referring to. It was a long letter to the PERC. I obviously don't have it in front of me, but what I think recollect was that there was clear reference to race, and that I would describe it as contextualising some concerns that the family had in consultation with Inquest. And Inquest, as I recollect it, was specifically mentioned in some of the paragraphs of that letter of the 31st of July to PERC. And it talked about, as I recollect, issues such as the use of discriminatory language and the association with a terrorist threat. And as I say, I don't have it in front of me, and I haven't read it very recently. But there was that reference. And what I do remember is that coincided with the meeting that we'd had, Lindsay Miller and myself, with Inquest. Now, as I recollect it, the catalyst for that meeting with Inquest was an invitation to the Lord Advocate, and I think the Lord Advocate was unable to attend, but Lindsay Miller and I went along to Mr Anwar's offices, and we met with Deborah Coles from Inquest, and that was all occurring at round about the same time, I think very close to the 31st of July. And the reason I mention that is, if it's of assistance to the inquiry, is that the concerns of Inquest were being highlighted by Mr Anwar and by I suppose I would say by association, by the concerns of the family as expressed through the consultation with Inquest. So all of that was occurring at the same time. It was the same stage of the inquiry broadly, and here were concerns about race being expressed by Inquest.
Thank you. Can we move on from this paragraph, please? And then you see the issue of race was specifically highlighted in my letter of further instruction to PERC, asking for confirmation that race and whether there was evidence of racial motivation was a primary focus of their investigation. We've heard evidence about that letter of the 2nd of September, and that's the letter that you're referring to there, is it?
Yes, it is. But I probably want to make it clear that the response by PERC to Mr Anwar's letter of 31st of July, that the Crown had been copied into that, and I cited the Lord Advocate on that. So to some extent it must have been clear, or I think it would have been clear, that by the time we got to our letter of the 2nd of September, PERC's response to Mr Anwar's concerns, including the concerns about race, had been copied to the Crown. So here was we might be going into the terms of the letter of the 2nd of September, but here was a further reminder in the light of the knowledge of the response that PERC had given to Mr Anwar in relation to race. Here was, as I've put it here, asking for confirmation that race was a primary focus of their investigation. And I don't know if that's a direct quote from my letter, but I know it was a short paragraph, but it was, I would suggest, quite directive.
And that was against the background of what you've just told us about, the meeting on the 14th of May, the letter from Mr. Anwar, and the steps that had been taken in relation to that.
The steps that had been taken and the comments and the description by Mr. Anwar as to why race was specifically a concern.
Thank you. We've heard from PERC witnesses that up until the point at which Mr. Anwar's letter of the 31st of July arrived, and then they noted in the decision log in the following month, we could maybe look at that briefly for the moment. If we go back to the policy log, PERC 04154, decision number 21. So this is Mr. McSpadden's policy log. We've looked at this before, and we're looking at decision number 21. This is cultural and religious issues. PERC flows will establish the religion and sect of the deceased and any cultural issues, seeking support where necessary from ScotGov lay advisors in order to provide appropriate support, advice and assistance to the family of the deceased, although not directed by Crown Office at this stage, take cognizance of any issue of race if they emerge. And then can we move down? And the reason given is provide appropriate support, taking cognizance of cultural and religious issues, address family concerns in a supportive and sympathetic manner. So you'll see there the focus is to some extent on the family and supporting the family.
Yes.
But there is also this phrase which says PERC would take cognizance of any issue of race if they emerge. And we've certainly heard evidence from Mr. McSpadden that in relation to this entry, that PERC were not directed by Crown Office at this stage in relation to race, but they would take cognizance of any issues of race if they emerge.
Yes.
We've heard from other witnesses. Sorry.
Sorry, I didn't mean to interrupt
Not
you.
at all.
Can I just ask, can you remind me of the date of this entry?
Yes, if we look at the bottom, 9th of May, 2015.
Right, thank you.
So this is the first entry in the policy log by Mr. McSpadden. And the phrase used is take cognizance, but we've heard from other witnesses such as Mr. Little that PERC would be mindful or keep an open mind about race. But we also heard that they did not pursue any active lines of investigation in relation to race during this period. And I'm interested in whether this description of PERC's approach to race, taking cognizance, which we can just see if we move further, there we are, taking cognizance of race, did that match your expectations of the steps that PERC would take to be compliant with Article 14?
I think the phrase taking cognizance suggests to me that, again, I've got to be careful that I don't speak for others, but if I give my own interpretation or my own perspective in respect to this, take cognizance is, that if you came across an issue, you would recognise it and decide how to deal with it. Mm. I think that there is clearly, as you've referred to, there's an obligation, there's an organisational obligation on those who are tasked with conducting an investigation to factor in specifically the issue of discrimination, which is wider, quite a wide term, discrimination, being treated differently. That to me suggests notions of being treated differently and being treated less favourably. I know that that's a term that's used in respect of discrimination. But take cognizance to me suggests you said keep an open mind. We'll be open to this if we come across it. Whereas active investigation, I suppose, an investigative strategy was something that I think, in relation to an effective investigation into race, would be necessary as the investigation progresses.
And were your expectations on the part of the Crown that PERC would pursue an active line of investigation? That they would, in terms of Article 14, pursue their investigation with vigour?
I think to be an effective investigation, those kind of descriptions are required, yes.
Can I ask you about the comment made in evidence by Mr McSporran that although we were not directed by Crown Office at this stage, I'm interested in, and it'll be a matter for the Chair, but there may be a view in PERC that it would have been required for Crown to have provided a specific instruction. Yes. And at that point, in the early stage of the investigation, there was no instruction. In fact, that didn't come until the 2nd of September. So during that period, there was no specific formal written instruction, and so they were in some way limited by their terms of reference or their written instructions. Can I ask for your comments about that?
My perspective in respect of that is that the instruction was to investigate the circumstances of the death of Mr. Bio, and it's implicit in that, in my view, that it is an effective investigation that has to consider all relevant aspects. I know it's a matter for the Chair, but and I think I said this in my statement. Although I wasn't involved in issuing the letters of instruction initially, I was aware that it was a general instruction, and that a general instruction to investigate the circumstances was sufficient at that stage to allow PERC to explore all relevant lines of inquiry. And I would say, from my own perspective, that it was inconceivable, in my view, that race would not be a relevant consideration, and certainly well prior to the 2nd of September, and to some extent, the wording of the letter to the PERC of the 2nd of September, it was the wording was seeking was it reassurance or seeking assurance or confirmation, seeking confirmation of something that the Crown considered was essential to an effective investigation, and therefore to that extent, I think my position is that I don't accept that it required a letter of instruction from the Crown to consider race. The letter of instruction was for an effective investigation to be carried out.
And I think we touched on this yesterday, that the witness interview strategy prepared for the police officers giving statements on the 4th of June had no questions in it about race. I may have mentioned yesterday that there were certain comments made by police officers within those statements using language such as coloured, making links between the coloured male and potential terrorist connotations. There was no PERC, we've heard evidence from PERC, there was no attempt during statement taking to probe into those possible attitudes, perhaps racist attitudes or language, and to ask officers about their state of mind or their motivation during that. No questions being asked at that time by PERC about history of any racist or discriminatory comments, misconduct on the part of the officers. And again, are those the types of things that you would have expected PERC to be doing, even in the absence of a specific instruction?
Yes. And it was those type of things that, of course, were to some extent highlighted, or to a substantial extent highlighted in Mr. Anwar's letter of the 31st of July.
Thank you. Can I then look at the Crown's position in relation to this period and regarding Article 14? What steps were Crown taking to vigorously pursue lines of investigation in relation to race during this period of time? Or was that left to PERC and their investigation?
I think the general approach of the Crown at the time of the submission of the first PERC report was that there required to be an assessment as to what's still required to happen, what was still required to be done in order to make that investigation in order to make that investigation effective, but also to allow the Crown to make a properly informed decision at a later stage as to the correct way or the most appropriate way to proceed. So to that extent, the letter of further instruction was to allow the PERC to review and to review their report and to carry out further inquiries, and the specific direction in respect of race was intended to direct them that required to be a further focus of their investigation.
We've heard evidence that in relation to the first report sent in August 2015 that it was 351 pages of a PDF, that there were multiple references to black male, black guy, 2 references to the threat level in the UK, 5 references to an increased terrorist risk, but there was no mention of race, racism, racist or racial discrimination. And there was no part of that report that was sent to Crown Office that covered race or discrimination, or Article 14 for that matter, in any way, not even to raise it and exclude it. In terms of the absence of consideration of that, was that something when you looked at that report from PERC that caused you concern?
It certainly informed the further letter of instruction that was sent to PERC.
As far as the Crown were concerned, when they received that first report from the PERC, and in the absence of any apparent consideration of race or discrimination, did you take a view about whether that report was satisfactory for the purposes of the Crown?
I carried out an analysis of that report as regards the effectiveness of that report and whether it enabled the Crown to take a properly informed decision in respect of the decisions that it had to take. And clearly, I consider that it didn't. And as I recollected, those to whom my analysis was submitted agreed with that assessment. There was no demurring from that. So to that extent, this was a stage, and I think I've said this in my statement, where the Crown were being directive and were being specific in relation to what required to be done. This was as a result of the analysis of the work that PERC had done to date, and so it was the report, and the report was, not short in terms of length. So it was quite a lot of consideration and a lot of material in it, but as I say, there was an analysis done as to what's still required to be carried out, and the Lord Advocate was satisfied that it was appropriate to have PERC directed to do that, and in effect to submit a later report rather than well, sorry, I'll rephrase that, to allow the PERC to address those areas of further concern.
Was it really the only option for Crown at that moment to try and get PERC to carry out further investigations and further lines to plug the areas that they hadn't covered?
It certainly was the view that this was the appropriate course of action to take, and I suppose I'm coming back to some of the observations that I made earlier on, that the PERC were the investigative body and the investigative skills set, and were able to make the approaches and to gather the evidence, and more particularly to analyse the evidence, because that was something that I think was clearly highlighted in my review of the first PERC report, that it included information, but it didn't appear to be the case that there was analysis of the evidence. And in essence, to my mind, that is an essential component of an effective investigation. It's not just what people have told you, so you put all that together. I know I'm being simplistic, but you get information and you put a spine in it and submit it. There has to be analysis, in my view, of where that takes us, and an assessment, a comparing, a sifting of information, and that was something that I recollect was a clear focus of the further direction that was given to the PERC, and to some extent that reflected the discussions that Lindsay Miller and I had with Deborah Coles, and in particular the reference to the Sean Rigg case, because I was directed or invited by Deborah Coles to look at Sean Rigg, and I did read the report on Sean Rigg, and I'm confident that I circulated it around the team, and I included reference to that in my analysis. But one of the concerns that Deborah Coles, as I recollect, articulated to us was that she said that in the Sean Rigg case, have regard to the comments that were made in the review about the effectiveness of the IPCC investigation, that it wasn't sufficiently rigorous in challenging the accounts of the police and various other things. And that was one of the key things that I took away from the Sean Rigg case, and that informed the review and the analysis that I carried out of the PERC report.
So from the Crown's perspective, you, having read through the first report sent from PERC to the Crown, there was no analysis of the information that they'd gathered, and there was no reference to race and discrimination.
I don't want to overstate this and say there was no analysis. There was. I consider that there required to be more analysis than there was.
And so in the absence of that level of analysis that the Crown were looking for, and in the absence of consideration of Article 14 race, from the Crown's perspective, did the PERC report meet your needs?
Well, it didn't enable the Crown to take the necessary decisions that it required to take, principally as to whether criminality could be excluded at that point. That was clearly a very important consideration, and that I didn't consider that the Crown could take that decision with confidence at that stage, and I think that was the focus of my my analysis, and there was general agreement that was required.
Insofar as that first report from PERC reflected the PERC investigation between the 3rd of May 2015 and the 7th of August 2015, is it fair to say that in terms of the Crown's perspective, it was simply not adequate for your purposes?
It was clear that significant further work required to be carried out.
And in relation to that significant further work, was there any other alternative open to the Crown but to go back to PERC and start taking what you described yesterday as a more directive approach?
I think there has to be a recognition that the PERC are the investigative body, that this is the kind of investigation that they were set up to carry out. And therefore, to that extent, that was the purpose. They were the investigators, and here was a Crown-directed investigation, and it was considered the correct course of action to instruct PERC or to direct PERC as to what further inquiries and work was required.
Thank you. I'd like to move on now to period 2. This was the period from that first report on the 7th of August 2015 to the 10th of August 2016. And I'll just very briefly, because I'm conscious of the time, set out some of the context during this period of time. So this is a period of around 1 year.
Yes.
Between the first report from PERC and their final report.
Yes.
Is it fair to say that during this period, Police Scotland are out of the picture entirely in the terms of, you remember I asked you questions about independence and ongoing involvement with Police Scotland yesterday morning?
Yes.
They're no longer involved during this period between the first and the final report. And yesterday we talked about your team, and I think information is available to the inquiry in relation to Erin Campbell's involvement at this stage. Now, I think as we understand the position, and you can tell me if I'm correct on this, she received a call from perhaps Lindsay Miller in August 2015. So this would have been round about the time that first report of PERC coming in. But her secondment to CAPD did not begin for a significant period. Now, I think yesterday you weren't entirely sure when she started. Was it during this 1 year period between the first and the final PERC report, or was it even later?
I'm very sorry. I've got an incomplete memory of this. The fact that the inquiry has evidence that she was approached in August 2015 probably doesn't surprise me, because it was an approach, and if it was Lindsay Miller, and I think it highly likely to have been Lindsay Miller, she was basically perhaps at that stage indicating you may be involved in this at some stage. But quite when she became actively involved, I couldn't be clear. I do have a very clear recollection that, and my recollection is this was one of the first things that she did, was that she was involved in the precognition of eyewitnesses. Now that's at a much later stage. That's after the submission of the second PERC report. So I have no recollection of Erin Campbell, being involved in an active sense prior to that time.
Thank you.
That's my own recollection. Having said that, I think that the inquiry might have come across a minute that she, our handwritten minute, where she'd attended a meeting prior to the submission.
You seem to know more than I do about this. We'll look into this over
Thank
lunch.
you.
But I think we do have information that she was involved at a later stage with Alistair MacLeod, but
Yes.
I'll deal with that in the third period after the final report.
Yes.
So during this 1 year between the first and the final report, you personally don't have a recollection of her being involved in the Sheku Bio investigation?
No, I don't.
And so was it really down to you what was being done during this 1 year period?
Well, it was. I certainly was involved in it, but I was involved in it with other senior officials, typically, in fact, very much Lindsay Miller and Stephen McGowan,
Right.
who'd been in it from the beginning.
All right, thank you. We've not heard from either of them yet. Well, before I move on, I wonder if you could give me a moment. Would that maybe
Well,
be
we'll take the break now, then 20-minute break. Ms. Graham.
Thank you. So I'd like to ask you some questions about the instruction of the first two experts that were selected. That was Dr. Payne-James and Dr. Karch.
Yes.
Can I ask, first of all, in relation to Dr. Karch, was the Lord Advocate involved in identifying Dr. Karch as the person that was to be instructed, as the expert to be instructed? And we've heard some people talk about the Lord Advocate as more as an entity than an individual. And I'm interested in what role the Lord Advocate had in actually looking through the recommendations from PERC and coming to a view.
The Lord Advocate wasn't involved, to my recollection, in the identification of Dr. Karch. The submission by the Commissioner, as far as I can recollect, was the first indication that Dr. Karch was being considered. Whether that was the very first indication that his name might have been mentioned in previous correspondence that he was being considered is a possibility. But what was made clear, to my recollection, was that an expert witness submission was going to be prepared and submitted to the Crown. Now, in respect of the actual decision to go ahead and instruct Dr. Karch, I couldn't speak to whether the Lord Advocate considered and issued an instruction in respect of that. I know that Stephen McGowan and myself were content that Dr. Karch be approached and instructed. And what I am also confident of is that, and I think the minutes bear this out, I made the Lord Advocate aware of the fact that PERC intended to instruct Dr. Karch, and attached the material that included the CV of Dr. Karch in respect of that, and there was no indication that the Lord Advocate had reservations about Dr. Karch.
And I think you say in your inquiry statement, no one had any concerns about instructing Karch at the time he was instructed.
Yes.
You've explained earlier that Dr. Payne-James and Dr. Karch had different specialisms, areas of expertise. I think you said Payne-James related to, although he's a physician, he had experience of restraint.
Yes.
And safe methods, and Dr. Karch was selected because of his knowledge in relation to the impact of drugs on a person's behaviour. Is that right?
Person's behaviour and the physiological and the psychological, but mainly the physiological, the impact on the body and the heart, I think.
Right. And as I think I said earlier, Kate Frame understood him to be a cardiac pathologist and a toxicologist. And I think you said that accorded with your understanding of his areas of expertise.
Areas of expertise, yes.
Let's look at the instruction letters for both of those. These were the first two experts formally instructed. They were instructed by PERC.
Yes.
In the circumstances you've described. So let's look at PERC 03434B. And this should be a letter of instruction that PERC sent to Dr. Payne-James on the 10th of August.
Yes.
And would it be fair to assume that the reports come in on the 7th of August, but this process of drafting the letter of instruction for Dr. James and Payne-James and considering him commenced prior to the report actually coming into Crown Office?
I'm sorry, I'm maybe not following
It's
you.
probably a poor question.
The
The process of identifying Dr. Payne James as suitable had commenced prior to the report coming in.
Yes.
But this letter of instruction
Yes.
is the 10th of August, which is after the report was actually sent to Crown Office.
After the report from Dr. Payne James?
No, after the first PERC report was sent to Crown
So,
Office.
I'm sorry, I'm with you
It's
now.
my
So,
fault.
no, I'm sure it's mine. Yes, I know what you're referring
So
to now. I
they
agree with all of that.
it
Yes.
spans the report coming in.
Yes.
So it's just 3 days after the report was received. And let's have a look at the content of this. So it's been, if we look at the bottom, we'll see that it is a letter from Kate Frame, the Commissioner. And if we go towards the top of the letter, there's an explanation about, there's been telephone discussions with Mr. Harrower. There's an explanation about what PERC are doing. And if we can go down to the instructions, there is a, thank you, please accept this letter as formal instruction for you to produce an expert witness report based on the information provided within the attached package. So that's a reference to the expert witness package, which we've heard evidence was attached with letters of instruction to experts. In this regard, expert witness opinion is sought from you on, and there's 4 topics there: physiological effect of the drugs detected in the toxicology sample, individually or in combination on the deceased in the circumstances of his arrest, the physiological effect of the CS and PAVA spray, individually or in combination on the deceased in the circumstances of his arrest, the physiological effect of the physical restraint of the deceased in the circumstances of his arrest, and the physiological effect of all 3 on the deceased in combination in the circumstances of his arrest. So it appears that for Dr. Payne James, you're also asking questions here, or PERC are asking, about the toxicology sample and the impact of drugs and the impact of the spray, as well as the impact of the restraint or the physiological effect of the restraint.
Yes.
So was his instruction actually wider than simply the physiological effect of the physical restraint?
It would appear so, yes.
Yes. And what expertise did Dr. Payne James have in relation to toxicology and the impact of drugs and the impact of CS and PAVA spray?
I'm struggling to remember exactly what his areas of expertise were. I would have to say that in respect of somebody who was being approached as an expert on restraint, they may be in a position to comment upon those questions. What I would be confident of, as a matter of generality, is that if they couldn't comment upon something and considered it was out with their range of expertise, because that is one of the functions of approaching an expert, that they would have indicated that they could not comment on that at all.
So rather than satisfying yourself that this expert had the relevant experience, there was an expectation that he would identify if he did not have relevant experience or skills.
If it fell out with their range of experience, then I would expect that they would do that. But
All right, thank you. And can we look at the letter of instruction for Dr. Karch? Please, this is PERC 03435A. This is a letter dated the 13th of August, so this is another 3 days later. Again, written by PERC, and if we look at the bottom of the page, I think again prepared and sent by Kate Frame. And if we can look at the instructions here, again it says, please accept this letter as formal instruction to produce an expert witness report based on the information provided within the attached package. In this regard, expert witness opinion is sought from you on A, the physiological effect of the drugs detected in the toxicology sample, individually or in combination. B, the physiological effect of the spray, individually or in combination. C, the physiological effect of the physical restraint of the deceased in the circumstances of his arrest, and D, the physiological effect of all three on the deceased in combination in the circumstances of his arrest. It would appear that PERC, in relation to this letter of instruction, have copied the wording exactly from Dr. Payne-James. So, in relation to Dr. Karch, who Kate Frame understood to be a cardiac pathologist and a toxicologist, clearly the question regarding toxicology would fall within his area of expertise. But where they're asking him about restraint and spray, were you satisfied that that fell within his area of expertise?
From my recollection, Dr. Karch's CV indicated certain areas that he had purported to have expertise in, and where he had obtained that expertise, but also his track record, if I can put it like that, in relation to the provision of evidence. And as I recollected, there was a very long list of publications. There was a very long list of the types of cases where he had given evidence. And to my recollection, there was a significant number of those that related to restraint in general. So to some extent, one was looking at not only his academic qualifications, but also where his expertise had apparently been used in a practical sense, and to a certain extent, he had I would say he looked as if he had a significant experience of giving evidence in relation to the types of issue that would be relevant to the case of Mr. Bayo. That's a very general recollection, but...
Were you satisfied that he had expertise in relation to physical restraint?
I was satisfied on the basis of the information that I provided to PERC that it was appropriate to approach him and to ascertain the extent to which he considered that he could provide expert opinion or expert comment on the aspects of this matter.
Again, was there an expectation that if he was unable to do so, he would draw that to your attention?
Yes, and I would say that that's it's an expectation. I think it's also a requirement on an expert to disclose whether they can in fact comment upon this.
And is that an expectation on an expert based in the US, as it would be in the UK?
I would consider that the obligations of an expert are broadly the same in respect of their obligations to a court, if I can put it like that, in respect of their provision of expert opinion.
And what do you base that on?
I base that on the fact that I should add that one factor in relation to Dr. Karch, which I think was highlighted, was that he had apparently given evidence in the UK. He'd given evidence in the well-known prosecution of Dr. Harold Shipman. And that was something that was highlighted, I think, to the Lord Advocate, but he therefore appeared to have some experience of giving expert evidence within the UK. And as I recollect, he had given lectures within the UK as well. But in relation to the generalities of the obligations of an expert, yes, that was an expectation. And I would say I personally, nor did anybody else within the Crown team, seek to ascertain what the professional obligations of an expert within the various states of the United States were, but that could be something that was later explored.
What relevance would his giving evidence in the Shipman case have had in relation to physical restraint or the use of spray? Was it to do with toxicology?
Yes. Essentially, I think yes. Toxicology would be, I would think, highly relevant to that particular case, and he was being approached, as I understood it, from a toxicological point of view.
Prior to instructing either of these experts, was there an approach made to see to what extent either of them could provide an expert opinion on any of these 4 topics that were of interest to the Crown and instructed by PERC? Was there a discussion with Dr. Karch?
I have to say, I don't recollect that kind of inquiry being made, and I was not involved in any such approach. Having said that, and again, I don't want to speak for others within PERC, the process of instructing an expert does normally involve some initial contact with them to ascertain generally their availability first of all, and then you go down to exploring with them the extent to which they would be willing and confident that they could provide an opinion. That is a standardised approach. And that is the approach that was adopted, I'm confident, by the Crown in relation to their approaches to some of the experts in this case, because I know that in particular Mr. MacLeod would approach and ascertain their availability and then proceed on that basis. And as I indicated in the inquiry yesterday, I was engaged in some discussions with a pathologist to try to ascertain the availability of an expert as well.
To what extent were you satisfied that that standard approach adopted by the Crown was being adopted by PERC? Because it was PERC that sent out these letters.
Well, I do refer to the fact that the proposal of the experts had I think clearly been sifted and assessed by the Commissioner, because it was the Commissioner who was, to my recollection, involved in the preparation of the submission, and that had been trailed with the Lord Advocate, whether in direct discussions between the Commissioner and the Lord Advocate or in correspondence, I don't know for certain, but I am confident that there was dialogue that indicated that the Commissioner, these were the proposals of the Commissioner having carried out some form of assessment as to the appropriateness of the selection of these experts.
Did you personally check about with PERC or with the Commissioner herself before these letters were sent out about the scope of the skills and experience that the experts had and their ability to respond to these questions and give expert opinion on these matters in any way?
I didn't have any direct dialogue with the Commissioner at that stage.
Did anyone else that you know of check with PERC about any of these issues?
I'm unaware of that. As I said earlier, I am aware that of Stephen McGowan in particular was aware of the proposals, but I didn't.
Thank you. And then the other thing that is absent from these instructions is any reference to cardiac pathology or issues regarding the heart. There's nothing specific mentioned there that I can see.
There's no mention of the heart. They are. I suppose they are quite general questions. that leave it open to the expert to comment, and perhaps that was one of the intentions in relation to the instruction. This was not a case where an expert was being approached for a single view, but rather a range of opinion being sought.
And was this a general or open approach to instruction of the experts seen as the most efficient or the best way to instruct experts at this point?
Well, what I can say is that there was no indication that it was not an appropriate way to approach them, having regard to the particular stage that this investigation had reached.
All right. Thank you. If we can look at we've mentioned earlier today your letter of the 2nd of September.
Yes.
And so we've been talking about the report from PERC coming in on the 7th of August. These letters went out to Payne, James and Karch shortly after, the following week. And then during this period between the report coming in and the 2nd of September, were you reading the first PERC report during this time?
Yes.
And let's look at your letter, 2nd of September, COPFS 02557. Now, if we look at the bottom of this letter, if we can go right to the end, this is a lengthy letter. It spills onto a 5th page, and it's written by you, Head of Cap D, Mr. Brown. And if we can go to the top, you'll see it's dated the 2nd of September 2015. So is this the letter that you sent to PERC after you'd had the opportunity to review the first PERC report?
Yes, it was.
And is this the letter that provided what you described as a directive approach, much more detailed instruction about the aspects that you wished PERC to cover?
Yes, it was. But I think I've said this, but I do want to emphasise that the analysis that I carried out did inform a briefing which was circulated round senior officials and the Lord Advocate, and therefore that was my analysis. So that was provided to the Lord Advocate, and then the letter was drafted, and as I recollect it, approved by the Lord Advocate in the light of my analysis. The letter wasn't sent in isolation. It was sent following a written analysis and submission to the Lord Advocate. And
did others have the opportunity to contribute in relation to the analysis of the PERC report?
Well, I think the answer to that is yes, because it was circulated with that, and it was circulated round others. Yes.
So, did others read the PERC report with a view to contributing to a more directive approach?
Yes, I think they did.
And who were they?
I think it likely that it was read by Stephen McGowan and probably Lindsay Miller. But they'd be better to answer that. But that would be my recollection.
We've still to hear from them, so we can ask what they did. But let's look at this letter, please. And if we can move down the page. And it says here, the Lord Advocate met with the family and their solicitor on the 26th of August. So this would be after the first PERC report. And that meeting provided the Lord Advocate with an opportunity to update the family on the progress of the investigation and to respond to a number of issues that were highlighted by the family. The Lord Advocate confirmed that PERC would be instructed to carry out investigations in respect of a number of matters in order that a properly informed decision be taken by the Crown as to the most appropriate way to proceed.
Yes.
And was this part of the overall plan that you would go back and ask PERC to carry out a number of further inquiries?
Yes, it was, and that was explained to Mr. Anwar and the family. But I consider that this initial paragraph was clearly indicating to PERC, in the light of everything that I said before the break, where there had been correspondence from Mr Anwar to PERC, there had been a response from PERC that had been considered by the Crown during the course of August, and this was advising the PERC quite clearly that the Lord Advocate had met with the family and their solicitor, Mr Anwar, recently, and therefore by implication this reflected the contents of the meeting and some of the issues that had been discussed at that meeting, and that is the way that this progressed.
Were PERC at that meeting, or was it only a meeting with the family?
PERC were not at that meeting, no, but PERC were due to meet with the family of Sheku Bayo very shortly after the 2nd of September.
But in terms of their instructions from the Crown, this letter was the method of communicating the instructions to PERC after that meeting in Crown Office.
Yes.
Thank you. And I think in your statement you say it was the first time to your knowledge that extensive further inquiry had been requested from PERC.
Yes.
Is that correct?
Yes.
So, and when you're talking about extensive further inquiry, is that this letter, which set out, spilling onto 5 pages, details of things that the Crown wished PERC to do?
Yes.
Had there been a discussion between you and PERC about the dissatisfaction, if I can put it that way, that Crown had with the PERC report, the first report?
There hadn't been any detailed discussion in relation to that. What I would say is that there was a degree of sensitivity at this time in relation to the terms of this letter, because it was appreciated that this was a very detailed letter that was being sent to PERC with detailed instructions. The approach of the Crown at that time, bearing in mind that here was the Crown asking PERC to carry out a very lengthy list of detailed further inquiries and analysis, that I would suggest that it was clear from that letter that there were aspects of the report that required further work to be done on it, if I can put it that way. But the approach, I think in general, was to try to support the PERC and to assist them at that stage, rather than to be overtly critical at that point, when the Crown was, the focus of the Crown direction was to give the PERC the opportunity to carry out this further work and to submit a subsequent report.
Right, let's look at the instructions that were given. Do we see the first bullet point on page 1? A detailed analysis should be prepared covering the accounts given by all officers and civilian witnesses in relation to the restraint process from beginning to end. So from your perspective, that had simply not been done.
It hadn't been done to a satisfactory extent. Yes, I think that's probably fair to say.
And then I'm going to take this short. The chair can read the letter in full. That account must thereafter be analysed and commented upon by an independent expert who is qualified to comment on restraint techniques that were employed. That person should be asked to provide an opinion as to whether the techniques were in accordance, if we can move the page please, in accordance with the training provided to the officers, whether those techniques were authorised and recognised, and furthermore whether the use of them was reasonable and proportionate in the circumstances. In particular, the expert should be asked to comment on the apparent decision not to remove the handcuffs and leg restraints from Mr. Bayo after he became unresponsive. That was a topic you touched upon yesterday.
Yes.
So let's look at this. This was a request or an instruction to carry out further analysis and to obtain the opinion of an expert in relation to the restraint techniques that were employed.
Yes.
Was this what Dr. Payne James was designed to provide, or was this separate?
No, this was not what Dr. Payne James was to provide. This was in order to, once the analysis of the information had been carried out, and so far as possible, a clear, or as clear as possible, a picture in relation to the restraint actions, the length of it, etc., that there was to be an expert comment on that in order to assess the approach by the police, and linked with that, whether there was any indication that those might be criminal. So I know it's much later on in the process, but the Crown obviously instructed a restraint expert. It was that kind of analysis that the PERC were being directed towards.
So in terms of the first report, is it fair to say that this work had simply not been done by PERC at that point? It had not been done to the extent that the Crown could place reliance upon it, yes. It was absent. PERC had not provided the opinion of an expert who commented on whether the techniques used in the restraint were in accordance with their training, whether those techniques were authorised, recognised, or whether they were reasonable and proportionate in the circumstances.
Yes.
And there was no expert opinion commenting on the failure to remove handcuffs and leg restraints.
Yes.
The next bullet point, an independent expert should be instructed to comment upon the circumstances of the deployment of CS and PAVA sprays, including an examination of the guidelines and an opinion provided on their use and appropriateness of deployment. There will be a similar process followed so that an opinion is obtained from a suitable expert on the drawing and use of batons during the process of restraint. All of these witnesses should be provided with evidence gathered from the witnesses, including civilians. It's particularly important that these experts are given the opportunity to comment upon all of the accounts given with the various witnesses, and there's specific reference to Ashley Wise's statement and a number of entries in that. Was this any reference to the instructions that had gone to Payne James already and to Dr. Karch, or was this designed to be a completely separate independent expert?
I think from recollection, it probably was a separate expert, although in relation to this, whether PERC considered that a further approach could be made to those witnesses, I don't know. I'm not entirely certain in respect of that. I suspect from reading it here today that it was for consideration of a further expert to comment upon these.
And so in terms of the first PERC report, no expert opinion had been provided by PERC whereby there was a comment on the deployment of sprays or the use of batons.
Yes.
And whether that was appropriate in the particular circumstances.
Yes. And just for clarification, now that I'd considered that aspect, I think it was clear that it was a further expert.
An expert who would look at the appropriateness of
Yes.
that deployment, and perhaps is this in relation to effectively justification for the use of force?
Yes.
Right. There was no the PERC investigation, as reflected in the first report they sent, did not cover justification of force in relation to sprays or batons. Is that fair?
From my recollection, again, there were areas that required further exploration in order to make a properly informed decision. Yes.
The next one, independent evidence should be obtained to comment on the guidance for deployment of sprays, and in particular any guidance on the importance of monitoring the condition of a person upon whom such sprays have been deployed, and an opinion on whether there is evidence of an appropriate level of monitoring of Mr. Bio's condition after deployment of the sprays and restraint measures. So there seem to be three elements mentioned there. Guidance for deployment of sprays. Is it safe to say that that is a reference to things like guidance from the OST manual or standard operating procedures?
Yes.
Now, we looked yesterday at a letter of instruction about standard operating procedures and the type of guidance available. Had the first PERC report simply not covered the guidance that was available in relation to sprays or their deployment?
From the terms of this letter, I think it had been assessed that further work required to be carried out in respect of those. I know that there was a particular focus, even from an early stage of the inquiry, on standard operating procedures, and as to my recollection, it had been highlighted to the PERC that a comparison with training in standard operating procedures, but in particular standard operating procedures, required to be incorporated into the investigation by the PERC. But this reinforces that.
So does it appear that PERC had not, to your satisfaction at least, observed that part of the instruction?
Yes, further work was required.
And then it also comments on the importance of monitoring the condition of a person who has been sprayed and monitoring his condition after deployment of sprays and restraint measures. And again, does this appear to focus on another issue about monitoring a person to whom sprays have been discharged and who has been restrained?
Yes.
And again, was that an issue that simply hadn't been covered by PERC in the first report?
Yes, it was an issue of concern that further investigations appeared to be necessary. Yes.
Then it goes on to say a toxicology expert should be instructed who can comment upon the effects and prevalence of the drugs found in Mr. Bio's body, and in particular alpha PVP and its use, prevalence and effects within a UK context. Now, we've heard evidence from Mr. McSporran that he was interested in alpha PVP. He explained that it wasn't something the investigators in PERC knew very much about, and he attended a conference in the US to find out more about alpha PVP. But I'm interested in this reference to a toxicology expert, obviously in relation to the letters of instruction we've looked at for both Dr. Payne-James and Dr. Karch. There's reference to toxicology. Was this a reference to a separate toxicology expert to be looked at, or was that
Yes.
in relation to Payne-James or Karch?
It was in relation to, I'm pretty confident, I think, that it was a separate expert, and the focus was on the effect that the drug would have. There had been inquiry, I think, at round about this time by Mr. Anwar in relation to the effect that this would have upon a person on their, I think, cognitive ability. And later on there was an approach to an expert in relation to that. So yes, that's why I think this was a separate expert to be approached in relation to the effect that this could have on a person's, I suppose, behaviour.
So there was reference to toxicology in the letter of instruction to Dr. Payne-James and in the letter to Karch, but this was designed to be a third expert in relation to toxicology. But this was about cognitive effect rather than physiological effect.
I think so. It certainly, there was a subsequent instruction of an expert for that purpose, and it might be in reading this that that was what it was referring to. I can't be certain.
Was it your view that 3 separate experts in relation to the issue of toxicology in the drugs was necessary, rather than simply identifying one expert who could speak to these issues?
As I say, it was an issue that was at large in relation to the investigation, and that it was something, as I recollected, that Mr. Anwar was particularly keen to obtain an opinion on, as regards the effects upon a person's behaviour that the drugs consumed would have, and how that interacted with the accounts given by the police in relation to what they observed.
Do you think this letter of instruction makes it sufficiently clear to PERC that it was the impact on behaviour rather than the physiological impact of drugs?
I think that if it was for that purpose, then it might have been appropriate to issue further direction.
And was it for that purpose that you wrote this part of the letter?
I just can't be certain in relation to that. I can't offer an opinion.
And then moving on, it says it will be essential to establish precisely what information was conveyed and received to each individual officer in relation to the incident prior to their attendance. For the avoidance of doubt, this information is entirely separate from evidence that is now available in relation to Mr. Bio's actions from various witnesses and accounts. The focus of the inquiry should be upon the precise nature of the information that was conveyed to the officers, primarily by way of police airwaves communications, so that it can be established what each officer's state of knowledge was on their attendance. In respect of the transcripts themselves that have been provided with the report, can you advise whether you can hear what is being said where the hashtags appear at various points? So this aspect had not been adequately covered by PERC either in the first report.
No, and I think in particular, the particular concern that I and others had in relation to this is that for the purposes of subsequent instruction of any expert in relation to the actions of the officers and the reasonableness of the officers' actions and whether it could constitute a crime ultimately, it was essential to pare back what they had been told prior to their arrival and not to conflate that with other witnesses who could and did speak to Mr. Bio's actions prior to the arrival of the police, but which had not necessarily been conveyed in the information that had been communicated to the police over the airwaves. So that is why there was that instruction and that direction to focus on that for that critical reason, that in assessing the behaviour of the officers, it was critical to know what they had been told rather than what others had perhaps seen, and also what they had said in their statements later on.
And again, that analysis hadn't been carried out by PERC.
No.
There's then, in respect of the various tablets seized, can you instruct a pharmacist to comment on what these are and what these are commonly used for? So that was another separate instruction. And then I require sight of the terms of your instructions to the pathologists who have been approached to provide expert evidence on the cause and mechanism of death. I note that at page 54 of your report, this is the first PERC report, that there is confirmation that Mr. Bio was handcuffed to the front and had leg restraints applied on his arrival at hospital. I require confirmation that all of the pathologists instructed have been advised of this fact and have been asked to comment upon the significance of this evidence. and in particular whether such restraint could have contributed to any positional asphyxiation, given the fact that these restraints continued to be applied after he became unresponsive and following resuscitation attempts. And then there was mention of the fractured rib.
Yes.
How many pathologists were being instructed? You talk about instructions to the pathologists who've been approached.
I'm sorry, I'm not entirely clear what that reference was directed towards. I'm obviously aware that there had been instructions to Dr. Karch and Dr. Payne James. Perhaps it was confirmation as to exactly what they'd been asked to comment on and the information that had been provided to them.
We've certainly heard of Dr. Shearer and Dr. Buhadir, who did the post-mortem.
Yes.
We've seen that there were instructions being sent to Dr. had been sent to Dr. Karch and Dr. Payne James, but this seems to refer to instructions being sent to pathologists, and I just wondered what was going on behind that reference.
I don't think I'm in a position at the moment to assist with that. I've looked at it and I don't recollect.
All right. Well, we'll move on, but in any event, you appear to have anticipated that further expert pathologists would be instructed by PERC.
Yes.
And these were specific matters you wanted covered?
Yes.
Was that because they hadn't been dealt with by PERC in the first report?
Yes, as I said yesterday, it was a particular concern on my part, and I think on others, but certainly on my part, as to what the effect of the non-removal of handcuffs had been.
Okay. At the bottom of the page we see, I would be grateful for an update on the forensic work constructed regarding comparison of the knife recovered with marks that were subsequently examined on one of the vehicles. And does this relate to the events leading up to the arrival of Mr. Bio at Hayfield Road?
Yes, it must have, yes.
And what was the purpose of that work being carried out?
The purpose of that work being carried out was to bring it to a conclusion, to ascertain what had been discovered or otherwise in respect of that, and to, I suppose, to assess the significance or otherwise that would have in relation to the overall investigation. It had clearly been instructed, and I wanted to know at that stage what the result was. I don't have a clear recollection as to my thinking in respect of that.
It's very specific in relation to the knife. We talked yesterday about the forensic strategy meeting on the 12th of May, and I asked you in particular about the Nicole Short's vest or body armour.
Yes.
That's not part of that aspect. What were your expectations in relation to that?
The expectations was whether in exploring, because I think in PERC's terms of references were to explore the behaviours up until the interaction with the police, and that was to some extent relevant to that. But beyond that, I can't really comment as to why that was included, other than I was obviously aware at the time that work was outstanding.
Were you satisfied that the work on Nicole Short's vest and the analysis in relation to that had been completed to your satisfaction?
I don't recollect having any update in respect of that at that stage.
But that's not been mentioned in the letter?
It's not.
Moving on, I've corresponded previously in relation to potential involvement of the Health and Safety Executive in the investigation of this incident. I understand John McSporran was going to facilitate a meeting with the Health and Safety Executive officials in order to discuss the evidence that is available to date, in particular in relation to the restraint techniques employed. Can you explain a little about this aspect obviously you weren't happy that the PERC report had adequately covered the issue of the health and safety aspect of the events at Hayfield Road. Can you explain to us why that was of significance to the Crown?
It was of significance because a potential health and safety analysis or investigation was considered appropriate, a consideration of whether there were any health and safety implications in respect of the incident. And this was, I suppose, directing the PERC that there had been discussions at that stage. The inquiry will be aware that there were direct approaches after this to the Health and Safety Executive, but this was, I suppose, giving notice that some form of dialogue with the Health and Safety Executive to engage with them at that stage appeared to be appropriate.
Thank you. And there was an expectation that Mr. McSporran, the lead investigator, was going to facilitate a meeting to take that forward. Yes,
and I was advised of that, and had obviously included that in this reference.
And then it goes on to say previous correspondence instructed PERC to examine where there is any evidence of an unauthorised access to and interrogation of the information systems of the Police Service of Scotland, and if so, whether this could constitute a breach of data protection legislation. And so this had been instructed, PERC had been instructed to carry this out. And you've said here this investigation should be carried out as expeditiously as possible.
Yes.
Were you not satisfied that this matter had been dealt with by PERC in the first report?
Again, clearly there was further work that was required to be carried out in order to bring that to a conclusion and to allow a decision to be made in respect of it.
It goes on then on page 4 to say, I require confirmation from the Commissioner that issues of race and whether there is any evidence of racial motivation is a primary focus in the PERC investigation. So this is the first reference to, specific reference to race in the letter, and in fact in your correspondence with PERC in relation to this investigation.
Yes.
And it is the point where you require confirmation that racial motivation is a primary focus in the PERC investigation.
Yes, race and racial motivation are both referred to, yes.
And was this against a background of you being aware that the investigation should be Article 14 compliant?
Yes.
The investigation should examine whether there is any evidence that any of the officers involved has expressed any racist views or opinions in the past. In particular, indicated that officers from within the Fife area had been investigated for texting racial slogans, and that one of the officers was referred to him. The family have inquired as to whether any of those officers apparently involved in that inquiry were in the group of officers engaged with Mr. Bio. So you've specifically asked for confirmation from the PERC.
Yes.
Whether there is evidence of where issues of race or any evidence of racial motivation is a primary focus of the investigation, and you specifically mention evidence of officers being involved in expressing racist views or opinions in the past.
Yes.
Would that have included comments made in their statements, because they're not mentioned? Or was the reference to the past a reference to sort of a history, perhaps, of disciplinary or misconduct proceedings?
This was a general direction to the PERC in relation to areas that related to race and potential racial motivation. Mm-hmm. It was seeking to highlight potential areas that the Crown considered should be investigated, and to explain the background to these and the source of the information. That particular aspect in relation to the racial texting of racial slogans, I think had been highlighted previously. I know that the identity of the source of the information has been blacked out, so I won't refer to that, but it had been highlighted to PERC, and I think I do explain in my statement how it came about that that particular investigation came to be investigated and highlighted to PERC. But certainly that had not happened at this point, but it was something that had been conveyed to the Crown, I suspect at the meeting that had been referred to in this letter, but as I recollect, also specifically to the PERC, because it was information that had that Mr. Anwar was aware of.
Right. I would like to go into this bullet point in some detail. Where it says the investigation should examine whether there is any evidence that any of the officers involved has expressed any racist views or opinions in the past. What was that a reference to?
It was a reference to whether any of the whether any of the officers who were involved in the incident had racism as a background, and whether there was any specific evidence of that.
All right. So that related to their past, their respective pasts. Was it designed to include any reference to their statements that they'd given on the 4th of June, or any analysis in relation to those particular statements?
Well, it was a general direction, I think, to the PERC to be aware of any racist views or opinions, and therefore anything that was relevant to the perspective that they had that was relevant to issues of race would be relevant, I think, by clear association.
There's no reference in this letter to an analysis of the statements.
No.
Or the language that was used.
No.
You've not picked up on the use of the word coloured or the link to terrorism, and any of those points that we discussed earlier. You've not specifically mentioned a separate analysis to be carried out by PERC in relation to Article 14 matters regarding their statements about what happened at Hayfield Road.
Yes.
And looking at that paragraph now, and this bullet point comprises the extent of race as a discussion topic in your letter, an instruction topic in your letter. Do you think there would have been merit in expanding this instruction to include an analysis of the statements?
With the benefit of hindsight, any direction that would have assisted in the inquiry would be relevant and would be of assistance. Having said that, I wasn't aware. I'm pretty confident at this stage that any such terms had been used. And if it had been an issue, then I would have considered that was an appropriate line of inquiry for PERC to make. But the focus of this at this stage was to issue a general instruction in relation to race and whether there was evidence of racial motivation, and also to reflect some of the comments that had been made by the family in relation to specific lines of inquiry that would appear to relate to that.
To what extent had you read the first PERC report in detail by the time you wrote this letter?
I had read the PERC report by this point.
To what extent had you read the officers' statements, the officers who attended at Hayfield Road?
I don't recollect whether I read those at that time. So that's, I don't have a clear recollection of reading those at that time.
So had anyone within your team read the statements of the officers who attended at Hayfield Road?
I'm not aware of the position in relation to that. The focus of the further instruction was on the basis of the PERC report, and in the light of the fact that there was going to be a forthcoming meeting with the family, and in the light of the fact that that PERC was due to meet with the family later on as well.
So at the time you wrote this letter, were you in a position to comment at all about the content of the statements that the officers had given on the 4th of June?
I don't know that I would have.
And so would you have been in any position to comment on the language used and the link to terrorism that we've been talking about? Would there have been...
Not the language.
No.
Not the language.
No. Would you have been in a position to comment on the link to terrorism, or a possible link being made with terrorism because Mr. Bile was black?
From my recollection, I think that might have been something that was mentioned in the report.
And it's not mentioned here. No. Would it have been of assistance to have some analysis done by PERC in relation to evidence about making that connection?
Yes, I think it would have, and I know that we may be taking this chronologically, but I think there was specific reference to that aspect of the case later on. But as I say, that this was a direction to PERC to focus on issues of race and racial motivation in relation to any relevant aspect of those considerations. That was, I think, part of the intention, but with specific reference to matters that had been highlighted at that point, and also bearing in mind, as I have said earlier on in my evidence, that this was a direction or a reminder, a requirement for confirmation that race and racial motivation was a consideration, against a background where very detailed information relevant to that had been provided to the PERC by the family at round about this time.
There was a recognition in Crown Office and by yourself that the first PERC report was, if I can summarise it, as inadequate. We talked earlier, there was no reference to Article 14 and investigation regarding race. There was an inadequate analysis of the situation. Was this not an opportunity in this, doing this letter on the 2nd of September, an opportunity for the Crown to say, we've looked at this in considerable detail. We've not just, we're concerned about the adequacy of the report, but we've looked behind that, and here's a large area that we think requires further explanation. Now, PERC have clearly not, of their own volition, adopted an active line of investigation on race, so perhaps it would have assisted if the Crown had said, this is what we expect of you. You've not done it yourselves so far, but we recognise that, and here is a much more active direction for you to pursue.
That was a possibility. Having said that, the investigation was still ongoing, and to some extent the attraction in having a general direction put PERC on notice that this required to be addressed, and required them at an organisational level to assess what required to be done in order to fulfil the requirements. So I don't disagree that with hindsight and looking back to that time, that any kind of assistance in addressing this would have been important. Having said all of that, there was the opportunity to actively engage with the family, which is what I would suggest the Crown had been doing. And when the family articulated specific concerns in relation to race, those were communicated, particularly in relation to the allegation of the sending of racist texts.
Well, can I ask you, regardless of the family's position, as I understand it, you accept that the obligations under Article 2 and Article 14 are on the Crown,
Yes.
regardless of what the family say or do. And you accepted earlier today that the obligations under Article 14 are in line with pursuing with vigour, a line of investigation that looks at race, discrimination, racist motivation. You've accepted that the PERC report, there's simply an absence of any sign of active investigation in terms of Article 14 in conjunction with Article 2. There's no reference at all in the first PERC report about discrimination, race or racism, not even to exclude it. You've identified that as a failing or a failure on the part of PERC. It would not appear, in fact, that there is any ongoing or active investigation being done by PERC at this stage. So, highlighting to them that you require confirmation that racial motivation is a primary focus, you know that that just can't be going on because it's not referenced in the first report. So I appreciate it is with hindsight, but do you see that perhaps this was an opportunity for the Crown to say, we expect more, and this is the type of thing that we expect?
I think it was an opportunity to more sharply focus the issue of race and racial motivation. I do consider that there were opportunities to engage and seek advice as regards approaches. Again, whilst I accept that the obligation is in all organisations to comply with the requirement, there was an opportunity for PERC to address themselves at an organisational level what required to be done. There is an opportunity to engage with others. There had been reference in previous correspondence to IPCC investigations that incorporated race. To some extent, the IPCC could be seen as a partner or an equivalent organisation to the PERC. So advice as regards how this could be effectively done, I suppose could have been sought, but I do accept that at this stage, some assistance, and with hindsight, some assistance could have been of benefit.
Because there is no reference in this bullet point to the IPCC guidelines.
No, there isn't.
There's no suggestion that they speak to other bodies or other people who might be able to assist in developing a strategy for this race investigation. And really the points mentioned there are really three. One, look at whether the officers have expressed racist views in the past. Look more generally at officers within Fife who've been investigated for racist texting and see if there was any connection. And then in the latter part of this bullet point, a specific issue about a potential history of racism in relation to one of the individual officers.
Yes.
But no wider recommendations or suggestions in relation to a race investigation or any other topics that could be covered.
Yes.
But in hindsight, you recognise that perhaps further detail could have been provided.
Yes.
In light of the failings of PERC to adopt a more active line.
Yes.
Thank you. I'm conscious of the time now.
Well, we'll stop for lunch now and sit at 2 o'clock.